All right, are you ready to proceed on?
I think as ready as we're going to be, Judge.
Okay. All right, we're going to go on the record. The man of the state of Michigan versus Ronald Probst Jr., 232537.
Good morning, Your Honor. Attorney Corey Westmoreland, appearing on behalf of Mr. Ronald Probst. Mr. Probst, would you please state your name for the record?
Mr. Ronald Probst.
Okay. And today is the date scheduled for the arraignment on this matter, as your client is currently in custody. And counsel, as to the arraignment.
Yes, Your Honor. I did have an opportunity to speak with Mr. Probst. At this time, we are prepared to waive a formal reading. My client stands mute.
Judge, may I say something?
Mr. Probst, at this time, I would just advise you to stand mute at this time.
I served in Afghanistan, man. I served 3 tours in Afghanistan, man. And it was no fun. I don't know why they're trying to accuse me of these problems of arson.
Mr. Probst, I'm going to stop you there. I'm going to advise you to stand mute.
I didn't do it, Judge. You know,
Okay.
I spent 3 tours in Afghanistan.
Right, sir,
I didn't do that, man.
sir,
Yes,
we're
Your
going to
Honor.
have to take this one thing at a time. So, the court's going to waive the formal reading. Enter plea of not guilty. Schedule this for pre-trial on December 21st at 9:15 a.m. And sir, you served in the military?
Yes, ma'am, I did. Marines.
Judge, at this time, I'm not really sure. I wasn't able to really get a full story from Mr. Probst. I would highly suggest that he should be having a competency exam. His stories just weren't aligning. Yeah, on the record just now, he indicated that he was in the Army. Now it's the Marines. I'm not really sure.
I've been all 4 branches of the military, sir. Army, Marines, Air Force, and Navy. I've been in all 4 of them, sir. I had 4 years in all of them, and 8 years in Afghanistan. You know, I'm about ready to retire, sir.
Mr. Probst, I'm going to advise you again to please stand mute.
So the challenge we have, counsel, is that the Center for Forensic Psychiatry doesn't do competency evaluations for misdemeanor defendants. There is another avenue perhaps that could be pursued that we'll have to look into before this next court date on Thursday.
I think he would greatly benefit from that, Judge.
All right, and so, Mr. Probst, where is it you're living?
I live in downtown Detroit. I live shelter for veterans, sir, Mel. It's on John R. Street. It's about a half a block before the VA on the left-hand side. I forget the address. I think it's 1440. I believe it is. I'm not really sure. They told me the address and I had forgotten now. I stay at a veteran shelter. Like, you know, here's the VA right here. It's 1 block up before there on the left. and I stay up there, man. And they got my competency check for the VA, the VA disability, PTSD, because I was wounded in war. I was wounded in a war. I caught a landmine in my right ankle as I was diving over a board, and it took off a piece of my ankle. So I was wounded in action, man. And they have a place there for wounded warriors, and that's at, you know, at the VA here on John R. going that way. There's a block up to the left. Block up to the left is a Veterans Administration. It's like a halfway house, and I stayed there for therapy for my ankle. I have to have a boot put on my ankle so I can walk, man. Yeah, I can walk. I can walk quite a distance. I can walk up to 7 miles a day, but without that boot, I'm in quite a bit of pain. And they administer my Tylenol 3 and my Motrin to me, and it takes care of the pain. You know, I'm in a little bit of pain right now in my right ankle, and you know, I caught the bus out here to see my uncle Mike, and I seen him, and I walked around the block there. I walked around the block, and they accused me of that arson. He lived right around the corner, and they accused me of that arson, and I didn't do it, man.
Okay, all right, sir. What I'm going to do, sir, is I'm going to order a $5,000 10% bond. In the event you post bond, you are to have a GPS tethered to the Wayne County Jail and no return to Citgo. And in the meantime, sir, hold on.
It's hurting, man.
In the meantime, sir, I need to make a record, so please just give me a moment. In the meantime, I'm going to look into what the other options are for competency counsel on the criminal misdemeanor matter. Okay?
Thank you, Your Honor.
All right. Thank you. Have a good day.
You as well.
All right. Thank you. Okay.
Hand me my screen box.
We are on the record in the matter of Ruben Quintanilla, 221167.
Good morning, Your Honor. Christopher Shumke appearing on behalf of my client. This time we consent to the matter being heard via Zoom.
Mr. Quintanilla, your name, please, for the record.
Ruben Quintanilla, can you hear me?
Yes, I can. I do apologize for your delay today, sir. Today is the date scheduled for a jail review, and you were set to, you were supposed to have a jail review November 28th, and you failed to appear for that. And so today's the date scheduled for that jail review.
Okay, yes, I spoke to Natalie, and she did address me with the email, and she made me she raised awareness of exactly what you're saying. I going through a bit of hardship financially, and my phone service was interrupted from the network that I subscribed to. So I lost communication for some time, and I still don't have a phone number, but I reached out via email, and that's when she reached out to me as well, and you know, brought awareness to it. I told me to not follow the court order or be you know, disrespectful to your order, Your Honor. I just trying to do everything set forth in a timely fashion, and I just you know, manifest hardship right now, and it's being progressive. I just recently gained gainful employment because that's what was going on. Is I was going to different employments that wasn't gainful. And
Yeah, Mr.
so
Quintanilla, I'm sorry, Mr. Quintanilla, I'm gonna have you stop right there. This court has been extremely patient with you. Extremely patient with you. And there's always a financial struggle for you. And then you're still driving. You don't even have a valid license and you're still driving.
yes, Your Honor.
Your last payment, sir, your last payment on your fines and costs has been September of 2022. That's been 15 months. 15 months. You have not cleared up your warrants. And then you're still driving without having a valid license.
And so
And whoever's talking in the back, sir, who's ever talking in the background needs to stop. They're not identified for the record and they're not your attorney of record. So they need to stop talking in the background.
okay. So sorry about that. My apologies, Your Honor. You know, you're absolutely correct though. You know, that's how hard it's been. You know, Edward Francis Martel, actually, you know, quite an expensive guy, and you know, a lot of funds went towards that. And also, just in my struggle, and just on 11th of December, I don't know what day it was last week. I just completed 1 year of sobriety, and just, you know, recovering and trying to get my psychic in order. My mental disparities was untreated, and just the whole struggle of the controlled substance that was really taking the control. And you know, thank you for giving me hope and not handcuffs. That really, honestly, that's what's the difference right there. It all makes a difference right now of what's currently going on and how I'm not delayed in payment and not really making payments. But now, again, now that I'm gainfully employed, I recently just earned $1,300 the last couple of weeks. So I can make a payment today of at least 100. And with the next 2 coming weeks, when I get paid again, it could be a higher amount of 400. And you know, I just want to knock it out as soon as possible. Honestly, Your Honor, it's you know, everything's expensive these days, and yeah, my health was the main priority, and you know, that was a very serious thing. And you know, thank you again for giving me hope and not handcuffs. And just the whole program, honestly, has been quite an experience, and I learned a lot. And you know, thank you for that, Your Honor. I do want to you know, follow what's set forth by Your Honor.
Sir, how have you been supporting yourself for the last 15 months?
So I actually lived with my mother and father. As soon as I got the case and was charged with what I was charged with, I you know, sought out my cousin, who's DEA agent, who referred me to Edward, and I spent most of my funds to fund his services to defend me. And right away, immediately, I sought out my father's, and that's who I reside with right now currently. So, you know, he's been a bit of a help, but since then I lost my job, which you know, really impacted me.
Sir, I understand. You lost your job quite a while ago. How have you been supporting yourself?
My family, my father. Again, I'm sorry, I didn't mean to give you the wrong interpretation. My family, my father, he's actually been helping me out a lot. And so, you know, also just with transportation is my biggest issue. Not having a license and paying a lot for transportation, Lyft, relying on, you know, if it's not my father, a friend, a family, and that honestly, you know, it's been a struggle. With transportation is expensive, and it racks up a bill really fast. You know, inflation right now currently, I'm not the only American struggling. This right here currently has made it that much more harder, and that's why I've been surviving. My family, thank God, you know, that you know.
Hold on, where are you, sir? Where are you currently situated? Where are you at right now? Because it looks as though you're in a hotel.
Yep, I right now my mother and father they're on vacation, and so my father put me in this hotel right now because he just want me in his home by himself. You know, I respect that. You know, he just wants to be there. Well, he wants to be there.
Sir, Mr. Quintanilla, Listen, you're giving me a whole lot of fluff. I'm just asking for basic answers.
Yeah.
What city are you currently located in?
I'm right now currently in Farmington Hills.
Okay, and whose birthday was it?
My birthday was on Saturday. So it was my birthday.
So were you there for a birthday party?
No. Actually, I have a friend come over and they gave me this as a gift and a gift as well. I actually work in the area of Farmington Hills, and so I didn't party. I actually worked all day on my birthday. I worked double. So I worked from 10
All right,
a.m.
if
to
you test, sir, if you test today, what's in your system?
again, as I stated, I just completed 1 year of sobriety on December 11th. Nothing's in my system, Your Honor. It's actually been a struggle for a while before I violated twice, and thank you again. It's been quite an experience. I've really successful in completing in my sobriety. I take it very serious.
Well, sir, congratulations on your sobriety. I know that was a huge accomplishment for you.
Yes.
And happy birthday. But sir, your last review is September 19th, and you've completed your outpatient counseling, you've completed your chemical awareness, and you've passed all tests. You've completed 5 of your 9 workforce days. You've been on probation now for not quite 12 months. And this court sentenced you to 12 months probation. So what I'm going to do, sir, is I'm going to extend your probation 6 months from February. You need to make a payment today. You said you have a payment to make today, correct?
Yeah. It's honestly, that was again my health and my psyche and the struggle with trying to acknowledge the whole fact that I was going to have a struggle, and I'm really glad and happy that you guys had that program, and awarding me the restitution so that way I'll learn a better lesson.
Mr. Quintanilla.
Yes.
You have $100 to pay today, correct?
Yes. I just what I'm trying to say, Your Honor, is 6 months. Like, what am I going to be ordered to do more work course, or what's involved in 6 months of the probation period?
I'm not understanding what you're saying, sir.
What's involved in the 6 more months of the probation period? Am I going to be ordered for more workforce and more programs to attend? I just want to know what.
No, sir.
Okay.
No, I'm not ordering more workforce. I'm not ordering more programs. I'm extending your probation because you haven't been able to get this done. And you haven't made your payments. So I'm extending your probation for those purposes. You're going to pay $100 today. What is that, sir?
I want to ask humbly and request if you could give me a probational period, because that a recovery program and my recovery coach going outpatient for inpatient was very expensive. I don't have health insurance. That cost me upwards of $15,000, and then Francis Edward Bartel was almost equivalent. It's just
Mr. Quintanilla, I am not ordering any more programs or anything of that nature. What I'm doing is I'm extending your probation 6 months because you've been on probation for over 10 months so far, and you haven't yet completed it.
I understand.
I said, and you also are continuing to violate the law and drive, and you haven't made a payment in 15 months. So instead of sending you to jail today, I'm extending your probation. If you don't want your probation extended, you can certainly report to jail.
I'm okay with the probational period. I just, was requested for at least 3 months. I can pay the balance off, honestly, by the next couple weeks. That's where I'm at now financially. And again, my apologies for the delay.
Okay, whoever's there in the room with you must not understand instructions because they continue to talk.
That's somebody who has their microphone unmuted, Your Honor.
I'm sorry?
That's somebody who has their microphone unmuted. There wasn't nobody here that's in my room right now.
I'm extending your probation 6 months, $100 today. And we will,
Your Honor, I have a public defender, am I paying that fee as well?
I'm sorry?
When there's a public defender representing me, do I pay that fee as well? Is there a fee for that?
I
Representation.
don't believe that there was not any fee charged for an attorney, sir.
Okay. Thank you. And curious to know.
We're adjourning the jail review to February.
Hallmark. This guy.
Sorry, what's that?
Oh no, I was making a comment to somebody else. Sorry.
Well, who else are you making a comment to, sir?
I have the door open right here. Room service just gave me toilet paper. They're putting it right down in front of the desk.
Room service brought you toilet paper.
Yes, I have my door unlocked currently.
Room service doesn't deliver toilet paper, but in any event, you were set to be, please stop interrupting the record. You were set to be on probation December 29 because you were sentenced in this matter in September. And originally I said February, September of 22. So I'm extending your probation 6 months. We're adjourning the jail review to February 13th. At 10:30 a.m. Thank you very much. Have a good day.
Hey, Your Honor.
All
All right, let's go off the record.
You read it. If you spit out in 3 months.
We'll see what happens.
You mumble.
And 23 CR 280 is called Horace Walker. That's you, sir?
Yes, sir.
Present with your attorney, Ms. Mantalini. You were charged here with this 3rd-degree felony of harassment by person in a correctional facility. And then there is a prior conviction. It's alleged in paragraph 2 of illegal possession of a controlled substance in this court. In last year, you were convicted. So if found guilty and true of these 2 charges, you're looking at 2nd-degree felony punishment, no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000 can be assessed. Okay, this is announcement day. What are we doing today?
He has rejected the state's
what's the offer?
recommendation of 5 years consecutive with his 30-year sentence, 30-year sentence.
Well, you're currently serving another sentence, aren't you?
Yes, sir.
Where was that at?
Here, Your Honor, he was sentenced to 30 years.
On which case?
Aggravated sexual assault of a child. That was clause number F20-34380.
When was that conviction?
November last year.
Okay. Okay, so see, it's not alleged in this indictment, so I guess it doesn't make a difference for sentencing, does it? It doesn't make him an habitual felon, right?
No,
Or
Your
what?
Honor.
I don't know.
No, Your
No.
Honor. It's still,
But it's not in there.
right, Your Honor. It's
But that happened
20.
before
Yes,
it's
Your Honor.
alleged he committed this event on February 28th or not?
Yes, Your Honor. Right before, I believe let me see.
He was sentenced in April, Judge.
No, it doesn't. He was sentenced in April on that one, so it doesn't enhance.
Yes, sir.
But I mean, it could be admitted in the case, during trial.
Yes, sir.
That doesn't help. If you're testifying, it's used as impeachment. But so again, the agreement was what?
5 years institutional division consecutive to the 30.
And your response to that is negative? Okay, then we'll set it for trial and we'll get this to trial as soon as we can. It'll go to, it probably we get to trial quicker if you agree to release her, but she's probably talked to you about that. We have these lawyers on the rotation wheel who are ready, willing, and able to go forward, but she's a fine trial lawyer. What do you want? But it's your, you get to make the choice. What do you want to do?
If it's the best interest, I guess I can release it.
Sir?
I'll release it.
Okay, that's what you want. Let's go to, yeah, it'll probably get to trial quicker. And if that's what you're anxious to do, then I find good cause to release Ms. Mantalini. The next person on the trial docket wheel will be assigned. Okay. 22-41237 is called Catario Richard Richardson. Is that you?
Yes, sir.
Present with your attorney, Mr. Dusler, and the state's attorney. There is a first amended motion to revoke unadjudicated probation. Does the defendant waive a formal reading of this? Can we proceed in a summary?
Yes, sir.
In summary, this motion to revoke your probation alleges that on January 30th, 2023, earlier this year, you were placed on 10 years deferred or unadjudicated probation for aggravated assault causing serious bodily injury, a second-degree felony. Is that true?
Yes, sir.
Number one, state you failed to report to the Jefferson County Probation Office for the months of April 2023 and May of 2023 in violation of your probation order. Is that true or untrue?
Yes, sir.
Was he a absconder or did he,
Son,
how long was he gone?
he only reported on his initial visit, which was March the 1st of this year, and after that, it went off.
Never came back?
No,
Is that true? The first one and then that was it? You had 10 years of probation. Oh, it just wasn't convenient for you? Or
Sir.
why did you walk off the job?
I wanted to report, but at the time,
Your feet didn't want you to be there.
no, sir.
You know, that's, if there's, the one thing you have to do is report. If you don't report, you're not on
Yeah.
probation. You're not on probation. That's the only way we can supervise you. We can't, there's 5,000 probationers. We can't go out and search them and plead with them to come back. You got a responsibility that you swore to when you were placed on probation right here. I will follow all the conditions of your
Yes, sir.
signature. I will follow all the conditions, and I know this can be revoked for any violation. All right. Just don't want you to be surprised with what happens next. Let me go to 5. You committed the offense of evading.
In a minute.
5, you committed the offense of evading detention on or about November 25th, 2023 in Jefferson County, Texas, against the peace and dignity of the state in violation of your probation order. Is that true?
Sir.
Huh?
Yes, sir.
Are you pleading true to that voluntarily and because it is true? You understand that one or more violations of your probation, if found true by a preponderance of the evidence or greater, are enough to revoke this probation.
Yes, sir.
Your probation,
Second.
can be revoked. You can now be found guilty, and you are looking at no less than 2 nor more than 20 years confinement in prison. Plus whatever prison time you serve, you cannot be paroled until 1/2 the time of service has occurred because there's a deadly weapon, namely a firearm, that was used in the commission of this aggravated assault. You shot somebody. Do you understand all of it?
Yes, sir.
Knowing that, do you insist on pleading true today?
Yes, sir.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true to this aggravated assault motion to revoke probation, the violations under that plea of guilty that we placed you on probation. I remember this. Yeah. This is terrible. Go ahead, Steph.
There's the whole reason why I handed you that PSI is when I look back at that original charge that we decided to give this young man an opportunity.
Attempted murder.
Yeah, it's not only that, but there's within the facts itself, there was a kidnapping that we chose not to move forward on.
Yes.
It's just a huge disappointment when you give somebody an opportunity to succeed and all they do is thumb their nose at the court and basically choose to do whatever they want to once we placed him on probation. It was only because of the count number 5 where he was arrested there that he's standing before you right now. That charge of evading detention was when we actually were able to place him in custody and have him stand accountable for the failure to do anything really on probation other than report the first time. Based on that, the state is suggesting a 10-year sentence.
You're looking at no less than 2, no more than 20, right?
Yes, sir.
What do you say?
Would you explain to the court, as you were trying to tell me earlier, your explanation for what's happened here and why you did not report?
I did want to report, but at the time, I had just recently lost my grandmother, and after that, I lost my aunt, both to cancer, and they were my main 2 supporters. So at the time, I really didn't have the support system I needed, and I tried to find work, but I couldn't. And I know I was supposed to report, but by this being my first time on paper, I really didn't know. And I am expecting a daughter on January the 8th. Like, honest to God, truth, like, I finally found a job, like, I only worked like 2 weeks. It was like a fast food job, but I ended up coming here.
Any job is a worthy job to begin.
I couldn't find work. And I was trying to find work.
That's not the point. The point is you didn't report, and everybody has to report.
I know
that's the easiest thing to do.
I know, but by this being my first time on paper,
No, sir. So, sir. No, I can tell you, you did it on your terms. You don't follow rules. This is it just needs to be read back into the record here how disturbing this was. In the middle of the day here. Police.
The charge that I'm on paper for?
Police, yeah, don't interrupt the court. You get a chance to speak, but only one of us can speak. If we speak over each other, the court reporter can't do her job. Police, in the middle of the day here in Beaumont, are called out to the scene of a vehicle that has multiple bullet holes in the rear of the vehicle. The victim had been shot multiple times and was transported to the hospital for treatment. The victim stated while she was placing her child in her vehicle, a red Mercedes SUV occupied by you and 2 others. Then don't shake your head. You're going to listen to this because this was admitted and everybody agreed this was true. You and 2 others pulled up and began to fire rounds into the vehicle. Multiple shell casings were located at the scene. The victim, I think, was a person who looks like they were 20 years old. How old was the child again that was in the vehicle?
It
says
I thought I had the right date, Judge, but that doesn't look accurate.
No, I'm not through. You get to speak here.
Let me
like to interrupt, don't you?
Let me look up that detail for you, Judge.
There was this was all in violation of a CPS order where someone was not allowed to have that child. And the child had been taken at gunpoint from her. The front passenger of the vehicle was you. You were in possession of a Taurus 9mm firearm. Apparently, the information and the investigation confirmed that you were the shooter in this incident. And you pleaded guilty to aggravated assault causing serious bodily injury. And again, I guess it was a miracle that a little child was not killed, that somebody else was shot. Here in the middle of the day in Beaumont. And what did you want to say? Go ahead.
I wanted to say that the child that was my nephew, and the only reason that I shot was because they shot at us first, and I had loved ones in the vehicle, and my nephew wasn't in the car.
What are you doing with a gun in the first place?
It was my aunt's.
No, what are you doing with a firearm, sir?
I had no business.
Why aren't you in school?
Sorry, Judge, took me a minute. The child was 3.
Child was 3 years old. That would have been capital murder. That child would have been killed. You'd have had 2 choices: life without parole or death.
The child.
That's how. Do you understand how serious this is?
Yes, sir. But the child was nowhere in the vehicle because when we pulled up.
So that's okay to shoot around town?
No,
shoot a vehicle.
No,
and shoot a person.
Before we got shot at, the child was already in the house because the woman took the child in the house.
How far did you go in school? Why weren't you in school on that day?
Because I'm not in school every month.
Yeah, I know. Why weren't you in school on November 17th?
Because I don't attend school.
Because you don't. How far did you go in school?
11.
11. And you just quit?
Not necessarily, but you can say that.
Okay, I will. That's the way this results. I mean, in the middle of town, y'all are shooting up this town with people in cars, shooting people. A 3-year-old child was in harm's way. And you, number one, you shouldn't even be having a firearm. That's craziness. Number 2, you don't shoot it at anybody in the middle of this town and drive around shooting at people from vehicles. This is chaos. What's the probation office say? You're going to get a chance to speak last.
Your Honor, when I took over his case, he was already an absconder. When I visited him in the jail, now he didn't mention to me anything about the ones that he said are deceased. He told me that he just wasn't taking probation seriously, and now he wants to take probation seriously.
All right. Go ahead. Anything else to add by anybody?
Anything else you want to tell the judge?
I just wanted to say, I do realize I made a mistake, and
which time? Which mistake are you talking about? I see a bunch of mistakes.
Both times, but I do want to say, if you allow me a second chance, I do want to complete papers, and I will complete papers. I just, like I said, I made a mistake, and I just want to do right on papers and finish it. I will finish it if I'm allowed to.
What state's asking again?
10 years, Judge.
There's a 3-year-old child involved in this, I guess.
Yes, sir.
Could I say one thing? The child, like I said, is my nephew. And
so that's okay to shoot at the child?
No, like I said, it was self-defense. They shot at us.
You know, what's odd is that's not what you pleaded when you pleaded guilty. You didn't take this. You could have gone to trial. You didn't do that. You insisted on pleading guilty to this, sir.
I really didn't know how to move forward with the case because I've never been in a situation like this before.
Anything else?
No, sir.
All right. There is sufficient evidence supporting this first amended motion to revoke unadjudicated probation to grant it by a preponderance of the evidence or greater, as allegations 1 and 5 have you have pleaded true to, and thus the motion is granted and you're deferred for unadjudicated probation is hereby revoked. And you were represented by Mr. Dusler here, who I can guarantee you informs people how to proceed and has been doing this longer than I've been doing this in the practice of law. And he advises people intelligently. There's no surprise here. There's never a surprise. Earlier in this case, you pleaded guilty voluntarily. You were mentally competent to do so. You understood the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1, admitted, finds you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this aggravated assault. And this involved the use of a deadly weapon, namely a firearm. And it states you pleaded guilty by shooting the firearm at the complainant, which she was shot several times. You were hereby found guilty of that offense. I now sentence you to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. A deadly weapon, namely a firearm, will be placed on the judgment, and it will be rendered affirmative finding on the judgment that that is found so based upon the evidence. You understand what has happened to this?
Yes, sir.
That is all. Don, what else do you have? Anything?
That's all I have.
Who's ready on something? Anybody?
I'm ready on this. You have
Come on. Yes, sir.
Judge, I sent this for a bond hearing. I filed the motion late, so the district clerk hasn't accepted it yet, but I do have a.
Who is it?
Jamel, he not speak to PJ Jamal.
Okay, Miss Manfellini is showing.
They're both.
Oh, that's right. You have a Jamel and a Jamal.
Yes, sir.
But I don't.
He's on the first page, about 4 down.
Okay. Mr. Petrie, make sure it is the right one.
Yes, sir. And if I could give you a copy of the motion, Your Honor, because like I said, the district clerk hasn't accepted it yet. And Judge, if you wouldn't mind me kind of refreshing your recollection on what happened here.
Hold up. Recall 2 cases, correct?
Correct.
23 CR 1654, which is the 2nd-degree felony of aggravated assault with a deadly weapon, and 23 CR 1858, engaging in organized criminal activity, a 3rd-degree felony. So we got a 2nd-degree felony and a 3rd-degree felony. Those are also alleged to have occurred on different dates.
Correct.
Actually, the more recent indictment is alleged to have occurred before, over a year prior to the.
It's because it was re-indicted, Judge.
Yeah.
This defendant was actually.
Well, no, that's not true. It's not. It's the date of the event is 2 different dates.
Correct. Yes, sir.
One is on June 4th, the engaging in organized criminal activity.
Yes, sir.
Of 2022, and then in October the following year, it is alleged that he committed aggravated assault with a deadly weapon. Was he on a bond or something?
Yes, Judge. Yes, Your Honor. And what's
good luck. That's going to be a high mountain to climb.
If I may, Judge, to properly remind you, he was on bond whenever the new charge came up, and counsel has been before you before with this request, and your prior ruling about that was that he would have no bond on this case that they're asking you to change your mind on.
Well, I'm always willing to listen to changed circumstances because I stand by the previous, but what I did and why I did it. But tell me what additional information you would like me to consider.
Well, Judge, at this point, Mr. Petrie has been in custody for approximately 76 days. During that time, his longtime girlfriend, Ms. McKnight, gave birth to a new child. And Mr. Petrie would just like to ask the court to give him an opportunity to have a bond set so that he can.
What was the point about that? I mean, what was the point? When was the child born? Is one of, I guess I'm going to lead to in logic. When was the child born?
November 13th. November 13th.
Last month.
Yes, sir.
Okay. So, this aggravated assault in 23 CR 1654 is alleged to have occurred on or about October 1st.
Correct.
Of this year, which would have been like about a month before the child is born. So you had to know that the lady was pregnant with your child. So what's your point? I mean, I don't understand. Just because a child is born, God's natural in life, the way life works, a child is born. But the point is, you knew a child was on the way.
And
so yet you're, and the presumption of innocence applies, but you're charged with committing a crime of violence. So why is the child being born important now? I mean, it wasn't important enough a child forthcoming for him to not get indicted for a serious aggravated assault. See? I mean, it's God's work. He's not doing anything about it. It's God's work. Is the child is being born, but she was pregnant with your child, and you must have known that, I guess. And then, but yet, with that obligation coming up, you decide, according to this indictment, to get involved in a serious offense. Let's see.
Just to remind you, Your Honor, this is the case that you've seen the video of the aggravated assault with a deadly weapon that occurs with 9 different defendants attacking one individual.
Yeah.
And just to clarify, Your Honor, I don't believe the state is alleging that Mr. Petrie actually used a weapon in that offense.
Well, that's what it says. It did then and there use or exhibit a deadly weapon. That's what it alleges here in this indictment.
Those are the accusations. When you break down each of the individual's responsibilities, at this time, I'm not aware that this Petrie actually wielded a weapon, but he was involved as a party to the offense and certainly was involved with the assault.
They indicted it as a party, which means he's got tantamount culpability by knowingly and voluntarily taking part.
Understood, Your
The
Honor.
way it's indicted. But I mean, the law parties carries with it the same culpability. But that's what happens when a group of people get together to hatch a bad plan that threatens the civility and peace of this community. Nobody, everybody's fed up with this. How old are you?
How old am I?
Yeah, I ask you first.
19.
Sir, how far did you go in school?
I graduated high school.
Okay, when?
2022.
Okay. Then what did you do after that? After you graduated, I mean, did you want to continue your education? Get a $40 an hour job at the refinery, since they're begging for local people to get these jobs, and we're having to have hotels built to bring out of towners to do the job because our local people aren't filling the jobs and they're getting in trouble. I mean, this is like money just falling from the sky here that is just going through people's fingers. We are blessed with opportunities. That $40 an hour gets you $100,000 with overtime, a little overtime, 6 figures, and you're messing around with this. This is hopeless behavior. Whereas we have opportunities here that are dreams of a lifetime of success. All you got to do is follow the rules. Get an occupation. 2 years at LIT and you're in the refinery and making a lot of money and being honorable and a role model for the family. That's what needs to be done. But too often I'm seeing this kind of behavior where people are frivolous in their actions. When you can see a refinery everywhere you turn, and there's gold right there. The good way. You don't have to hurt people or threaten your life and others. Anyway, that's my Christmas wish, is that people would change their behavior, finish school, get a trade, and go make money and be a role model of good. It's right there. No, we build hotels to bring out of town people to take the jobs that are right there. They have the jobs, but our people getting in cars and shooting up the town, beating up people. No, that's foolish. But it's a choice that you can make. I mean, we're blessed. You can see from most parts of the city refineries. So you can be reminded, there it is, waiting for you to help. And they make things that are good for civilization. It's right here in this town. But anyway, that's
Judge, Mr. Petrie does have some experience in the electrical trade, and he's
yeah, he needs to be taking advantage of that. But you can't do it sitting in jail. Don't have a lot of people in the union in there. Those are get into a union, and those people are disciplined. They've got a trade, and they take great pride in their work, for example. But you're on the outside. They're on the inside. You're on the outside because of a choice you made. No, this is serious. And the bond, I don't see any difference, especially in what I've delineated. You're saying now a child is born, but the child was almost born when you made a choice, according to this indictment, to get involved in a terrible deed. No, the motion is not. I don't see any really changed circumstances from the circumstances. But anyway, we'll set it for trial, but something needs to be done in your life to salvage your life, because I can guarantee you that the people are fed up, and those people make up juries, and when these juries, I can trust them. They make pretty good decisions when the evidence is presented. You need to figure a way to fix this somehow and start doing the right thing. Maybe getting a trade or in something so that you can get back to the community and get well rewarded by the people who want to give us want to provide jobs for this area. And we're given first shot. That's what's amazing. And we're passing it up. People aren't able to do the job because they're not prepared. And it's simple. Just get an education, a trade, and stay out of trouble. And then you're 6 figures. Making more. But it's that simple. I get frustrated watching it. It's like water going through our fingers. But no, the bond has not changed. I would suggest maybe y'all need to work on something, or we'll set it for trial, but maybe there's something can be done to fix this, where it doesn't sting so much and he can make a second chance and make the most of it. But this is, you did something that's a mess that has to get some people involved to fix. But you're going to, at the end of the day, you're going to have to carry the load by simply making the right choices, which begins with running around with people who are better than you, not worse than, because people drag you up. They will drag you down if you run around with the bad people. You'll get down, they drag you to the lowest common denominator. That's the way it is with the groups. You want to get in the group that's even better so that you can rise. I'll set it for trial. That's what we'll do. Thank you.
Thank you.
And then decide if y'all got something else changed where we can, and I'm ready to go whenever y'all want to work something other than trial, but We're at 550 trials, so we're trying cases just as fast as we can.
Nice signature, Judge.
Thank you, sir. All right, in Van Moore's case, that's you, sir?
Yes, sir.
And you were here with Mr. Dusler, your attorney does the defendant. We have a formal reading of the indictment and agreement here. Can we proceed in summary?
Yes, sir.
And here he's charged with a 3rd-degree felony of continuous violence against the family. That's not good, especially during the Christmas season. And then you've got a DWI 3rd out of this court back in 97, before I was even born almost. And that means that you're looking at 2nd-degree felony punishment up to 20 years in prison if we went on all of these. Do you understand?
Yes, sir.
You got a 3rd-degree felony, a prior conviction enhances it to a 2nd-degree felony. You understand?
Yes, sir.
What are we going to do in this case?
Proceeding on count 1, the agreement is 10 years, probated for 10 years, $500.
Can I do that on continuous violence against family?
Yes, sir.
How long have you been in jail, sir?
45, 50 days. So.
Mm-hmm. Well, it's not going to end that quickly with me on something like this. All right. Does the defendant again waive a formal reading of this indictment in paragraph 1 here, this allegation 1? Can we proceed in summary?
Yes, sir, we can.
In summary, this allegation alleges that on or about October 28, 2023 in Jefferson County, Texas, you committed the 3rd-degree felony of continuous violence against families. In that on or about October 27th, I guess, of 2023. It doesn't show a date of year, but it's inferred it must be in the same, within the same time frame of the allegation of on or about October 28, 2023. That you struck the victim about the head and body with your hands and caused serious bodily injury, who the victim was a member of your household. And you had more than one such act within 12 months or less in duration, which causes it to be a continuous violence against the family. Do you understand what you're charged with here?
Yes, sir.
This is a 3rd-degree felony if convicted, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement's been reached where you would be sentenced to 10 years in prison, which you're not eligible to get probation for here in front of a jury. Do you understand? Because of your prior convictions, you went before a jury and were convicted, you don't get probation. You are allowed in front of this court by pleading guilty to be placed on probation for 10 years if I sentenced you up to 10 years in prison, and this would be a fine of $500 as well. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Can you understand?
Yes, sir.
How do you plead to this 3rd-degree felony charging you with continuous violence against the family? Guilty or not guilty?
Yes.
Are you pleading guilty of voluntarily, that is on your own free will,
Yes, sir.
and because you are guilty?
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it? Discuss it with your attorney?
Yes, sir.
Are the contents true and correct? State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you were mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you, or you've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses, and you were totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. Do you understand? Is all of that true and correct?
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Well, that's terrible, to say the least. Well, you made a holy hell out of somebody's life here. Are you on drugs or something?
No, sir.
This is the way you normally act, sir? This is the way you act?
We would
No, I know. I'm reading this report. First, this is 3 assaults within a matter of hours. You knocked the lady out of the chair she was sitting in. You used the closed fist, struck her in the head, and kicked her in the buttocks, and then ran from the scene before the police could get there. Then, a little later on, you met up with her again, threw her to the ground, put your knees into her side, and shoved her into a wall, causing a hole in the wall to occur. Then you promptly left the scene. Then shortly after that, you showed up again a 3rd time and snatched a phone out of her hand, struck her in the ribs with the closed fist, threw her to the ground, causing pain. And then the police showed up finally. And while you were there this time, and you were taken into custody. Well, that's kind of disturbing behavior, wouldn't you say? Anything else to add by anybody?
No.
If not, I'm going to find in this case you have pleaded guilty voluntarily. You were mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. Do I have I now find you guilty beyond a reasonable doubt? Do we have to? And I'm following this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 10 years. Fines $500. We put 1,000 there. That's inflation.
I'll fix that.
That's just moving up fast. You're sentenced to 10 years in prison. That is suspended. You were placed on regular probation for 10 years. You must pay a fine of $500. There will be terms and conditions of probation which are necessary for you to successfully complete this probation. You're on thin ice with this behavior and your criminal history. Do you understand? So one of the things you're going to have to do is this batterers intervention program, which is a great program that is directed by Family Services here in Beaumont. You must attend and complete that. There will be other terms and conditions of probation which are normal and customary for this type of behavior. And this court is going to there's a condition of probation which I'm going to order, which is 180 days in the county jail. I'm going to do what I can to make sure that they spend Christmas without you. You are a living hell. 3 separate assaults to this lady, 3 separate assaults, and then you ran away like a scared little girl each time before the police arrived. I'm going to give them a chance to at least enjoy Christmas with some peace. You are the Grinch. That's all. You come back before me, and I'll remember this set of circumstances, because this is anti-Christmas behavior. And 10 years isn't enough for the holy hell you've had to place over your quote family. You are disruptive of the family unit. You are a violent, angry person who needs a long time out. Maybe you can think about the blessings that you have that you're ruining, not only yourself, but others that have to endure your victimization. This is not right. So that is the ruling of the court. That is all. Okay. That should do it. Anybody else?
I have a case.
I don't hear anyone. Anyone else at all? Wait. Are you Little Langston's father? Then you're first row, buddy. Come on up.
Come on up. Thank you.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're going to start bringing people in person. People going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am, can you hear it?
No, I know.
Okay.
I have no patience for that. But trust me, out of the day, I'm sitting up here, I'm the one that needs the drink.